that you're not competent at this time to stand trial. Find that inpatient competency restoration is needed, and order that you are to go to an inpatient. Roderick James. Mr. Smith, this is yours on Roderick James. Good morning, sir.
Good morning, man.
You're Roderick James. And this is cause numbers 26 DCCR 0388. Mr. James is charged with assault on a peace officer, and 26 DCCR 0389 also charged with assault on a peace officer. I'm going to take judicial notice of the court's file. Mr. James was evaluated by Dr. Hamza for competency to stand trial. I've received that report. It is dated May 12th of 2026. And in that report, the finding is that Mr. James is currently not competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. Nothing said.
Then at this time, I am going to find, Mr. James, that you're not competent at this time to stand trial. Find that inpatient competency restoration is needed, and order that you are to go to an inpatient treatment for a period of not to exceed 120 days from the day you get there for competency restoration. So you're going to go to a hospital. They're going to get you some help so you understand everything that's going on, and then we'll get you back and go through your case, okay? All right, you can go back with the bailiff. He's going to take you to the back. Mr. Kimler on Ibriana Bell.
Ready. Right. Third. The day may come, but that's not today. You already said it first. Oh, you said it. What's the state? State of Texas first, right? Kim, I don't think we're there yet. But...
Good morning. Are you Ibriana Bell? And will your client waive the formal reading of the indictment?
So
Ms. Bell, on cause number 25, DCCR 1610, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from August 14th of 2025. The indictment alleges that you were previously convicted of theft April 7th of 2021, August 16th of 2021, and then November 10th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
What was the result of the last one, which is a felony number?
we successfully completed deferred adjudication is what I saw here.
Okay, well, we're not doing deferred adjudication again.
Okay. After today.
No, today we're not going to reward the same behavior with another deferred probation.
Deferred.
I don't care what it was. You just got off probation. You were on probation 3 years ago. So yeah. Yeah, it's a cause number 22-39877 in CDC from 2022 is the third. So this makes the fourth and the second felony. I'm not saying I won't consider a probation, but I think if I don't see any reason why she would deserve a deferred probation.
Well, it's just that, I guess, not saddling her with a felony conviction.
What's stealing? You won't get a felony conviction. So I'm gonna I'll either hold it. If y'all want to renegotiate, I'll delete the paperwork. Y'all talk for a few minutes. I can keep the paperwork and make some adjustments if that's what y'all want me to do, but I'm not going to agree to a deferred probation. All right, so I'll hold it. Go have a seat.
All right. Thank you.
All right, ma'am, you're Ibriana Bell again, correct?
Yes, ma'am.
And we've already gone through that she entered a plea of guilty. Well, actually, let's go back because I don't even think I went too far with all of that. Will she waive the formal reading of the indictment?
So
So, Ms. Bell, in cause number 25 DCCR 1610, you're charged with the state jail felony offense of theft of property with previous convictions from August 14th of 2025. And how do you plead to that charge?
Guilty.
And then your indictment alleges that you were previously convicted of theft of property April 7th of 2021. After that was final, August 16th of 2021. And then after that, November 10th of 2022. And are those true or not true?
True.
Did you enter your plea of guilty and true to those allegations freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And what is the agreement that you guys have reached? And is there any issue with me changing the agreed punishment recommendation page to reflect it?
Your Honor, we've agreed on a straight probation of 2 years in state jail, probate over 3 years with a $500 fine, $221 restitution.
Correct, Your Honor.
And I have no objection to the court making those changes.
That's the current agreement, Your Honor, is reflected in the altered or corrected punishment recommendation, agreed punishment recommendation.
All right. So what the agreement is for a 2-year term in the state jail prison, that would be probated for 3 years. You would be ordered to pay a $500 fine as well as restitution in the amount of $221. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Bell is not competent?
None I'm aware of. Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That's going to give me more information about you, your case, your history, and then we'll come back later for sentencing.
Yes, ma'am.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes, ma'am.
All right, we'll see you back at sentencing. Miss Bell. Hey, Miss Bell, come back for a sec. If I test you this morning, you gonna have anything in your system?
No, ma'am.
Okay, let's double check that, okay? Have a seat right over there so I know for sure. All right, so you're Larry Fletcher Jr.
Yes, Your Honor.
And this is cause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial on these 2 cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set, but is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. He's not allowed to drive. And so, this was not an alcohol, like it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and of speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
Yeah.
Judge, we were just alerted to all of that at the same time the court was,
Yeah.
that was filed Friday afternoon at 4:00. So.
Well, it is what it is. If there's something in there that you find that is not accurate, then just let me know, file a supplemental motion, but at this time, I'm going to deny the motion to modify, the bond and, conditions. We'll get it set. It's already on the trial docket.
It is,
correct?
Judge.
All right, but it'll go back right on the trial docket. And again,
And-
if there's something that's changed that's not correct, let me know.
Okay, and I think Mr. Coleman has filed a supplemental motion to revoke probation too, which will have to be heard at some point because we're going to plead not true to that as well.
We'll go over any motion to revoke, after.
He may not have filed it yet. He may have just told me he was going to file it, but
So. That, the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct? Okay, all right. If something comes through that, I need to hear, but my thought is still to go forward with the trials first and then to deal with the probation,
I understand.
unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, and let me back up and say, it's not a new case. In the wake of the motion to revoke probation hearing, Mr. Coleman filed a federal case relating to the
gun that
other
was
stuff.
found?
Yeah.
Okay,
So and he's not a convicted felon, but we'll argue that when it's time to argue that. But that's what the new case is.
okay. That was something that I've already heard in that motion to revoke to some extent.
Correct. Yeah.
Okay, all right. We'll see you back at the trial date then. Morning, sir. Are you Malik Ellis? And will your client waive the formal reading of the motion? Mr. Ellis, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? So, Mr. Ellis, in cause number 17-26733, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 9th of 2017 for the second-degree felony offense of aggravated assault with a deadly weapon. And that was a 7-year deferred probation that has been extended for 2 years. Is that correct?
Speak up.
And then the allegations that you violated your probation are in count 1 that you committed the new offense of possession of marijuana, Class A misdemeanor, November 18th of 2025. And is that true or not true?
Not true.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Not true. Count 3 alleges that you provided urine samples March 23rd, February 21st, July 14th, and November 20th of 2025 that tested positive for THC. And on March 23rd, you also tested positive for methamphetamine. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample. That's this. I don't understand count 4.
And same thing.
Mhm. You want to abandon count 4? Sure. State will abandon 4. Count 5 alleges that you possessed illegal drugs, namely marijuana, and that you were arrested for possession of marijuana November 18th of 2025. Is that true or not true?
I think you may have been arrested, but that's not a violation.
Well, it says he possessed it. He possessed illegal drugs, marijuana.
I don't know. Believe it be construed that he's pleading not true to being arrested.
I understand it. It's really worded kind of both ways, and so I'll just do not true for 5. Count 6 alleges that you are behind in your court assessed fees as of December 12th of 2025 in the amount of $7,031. And is that true or not true?
At the time. True. True.
As of December 12th of 2025.
True. Not true. I know that's right.
All right. Did you enter your pleas of true to counts 3 and 6 freely and voluntarily? And because those counts are actually true. As a condition of your bond right now, are you required to wear a drug patch? You have it on. Let me look. Hold on. Let me look at it. That's fine. Just want to look back and make sure. Have a seat in the jury box. The last one was positive.
The drug
Have a
patch.
seat. We're going to get you tested. All right. So Mr. Ellis, tested negative. So that's good. Just continue with the drug patch. Make sure you don't use anything so that they're all negative from this point forward. Okay.
And I just took one. And
It's a lag time from the time it gets turned in till the time we get it. So it's been a little bit. So you're fine. Okay. So, we'll just reset your case for a hearing. We'll just do an 11 o'clock hearing. Should be plenty of time to take care of what we need to. Make sure you continue doing everything that you're supposed to on probation. Stay in touch with your attorney and we'll see you back for your hearing. All right. And then